Welcome to our audience from all over the world, where you will be joining us in a fascinating conversation about gaps in the international legal framework on violence against women and girls. Welcome to the Carter Center Forum on Human Rights. We're very happy for you to join us about this very important topic. It's a difficult topic, but we need to talk about it. We need to find solutions. Former President Carter has long talked about the human rights of women, and in particular, violence against women, being the most pervasive human rights violation on earth. This happens in every society, from the most affluent to the poorest, from all walks of life. We see violence against women as a seemingly intractable problem that is with us, all around us, in our families, in our communities. In the most extreme examples that we can come up with to talk about why it's so urgent for us to talk about this and for us to find solutions. 8 years ago, former President Carter, who's the founder of the Carter Center, wrote the book, A Call to Action. I don't know if this is in reverse, but this is A Call to Action, Women, Religion, Violence, and Power. And it was a book really calling attention to the idea that violence against women is this intractable problem that we all must look deeply within to solve. It is incredible that even today, 1 in every 3 women around the world, one out of 3 women, 33% of the women in the world have experienced violence, sex-based violence against them. Violence because they are a woman. We see still the problem of female infanticide in many parts of the world. Whole millions of missing girls and women because they were aborted only for the reason of being a girl. We see the constant news about violence against women in war, targeted as women, as war crimes, specifically targeting women. So what is there to do about it? In our own societies, we have the idea that if there is violence perpetrated against me as a woman, that I can go to the authorities, I can make a case against that person who has assaulted me. But we know, for example, in the United States, that young women in college can almost never see justice against a perpetrator of rape against her, almost never, even though a large percentage of women in college have faced sexual assault during her 4 years in college. In our military, we see thousands and thousands of cases of violence against women every year that go unpunished. So this lack of accountability is an enormous part of the problem, that perpetrators of violence against women do not face consequences. Another part of the problem that we face is social and religious norms that normalize violence against women. That women cannot have a voice in society because of social and cultural and religious norms. They cannot speak up for themselves when they are assaulted. And of course, social norms, certain practices against women and girls are practiced under this banner of culture and social norms. So we have seen that when communities tackle this, really going after the social norms, we can see transformation. So it is not a hopeless situation, and we are really happy to have our panel today to talk about why we need a new global treaty. This is the subject of today's program, to really push us towards more accountability for those who commit violence against women. So I'm really excited to introduce our panelists. I'm going to begin with Francisco Rivera, who's a human rights lawyer from Puerto Rico, working at the Inter-American Court of Human Rights, and is now a law professor at Santa Clara University Law School. Francisco has been collaborating with the Every Woman Treaty since 2015 and co-authored Safer Sooner, a report on the need for a new treaty to end violence against women. Welcome, Francisco. Can you tell us, why do we need a treaty, a global treaty to address violence against women?
Thank you, Karin, and thank you for inviting me. Yes, so at Every Woman Treaty, we think that this specific treaty, right, addressing violence against women is needed because what we have now, the existing international human rights legal framework, is woefully insufficient. It is complicated to understand. It is outdated. And it is not as specific as it needs to be or it could be, right? And we think that we can do better, right? We can build from the existing framework because it's what we, the international community, have always done, right? International human rights law is always developing, and we see no reason for it to stop developing, particularly for the reasons that you've highlighted because of the importance of a pervasive nature of violence against women. But let me step back and explain. I think we need to understand that when we say international human rights law, we mean treaties that are binding and soft law that it's not, right? And in terms of the treaties at the UN level, there's really just nine, right? And they can really be divided into two groups. One is general or generic treaties that cover sort of like, all human rights for all types of people. And you have more specific treaties as to subject matter or as to, specific persons, meaning that they cover specific rights for specific groups of people. So in theory, right, and that's what the other side claims, there's no need for any more specific treaties because the general treaties, already provide binding obligations that can then be interpreted to apply to more specific contexts. But that's not what the international community has done, right? We have decided that some issues are so important, right? That some categories of individuals, require so much more specific attention that more specific treaties are necessary. And let me just give you a couple of examples, right? If you look at the ICCPR, the UN Treaty on Civil and Political Rights, it includes a whole bunch of human rights, including the prohibition on discrimination, and that includes against women. It also includes a specific prohibition on torture, right? And that treaty covers all people, including women, right? So there's really no need to have something like CEDAW, or there's no need to have another treaty on racial discrimination, but we decided to do so anyway. That's why we have the Convention on the Elimination of Racial Discrimination, which is more specific. We have the Convention Against Torture, which is more specific than the ICCPR. We even created a committee to oversee torture and a subcommittee because it was so important to address prevention of torture, right? So that's basically, our argument. This is the normal development of law, whether in the international sphere or the domestic sphere. And that's why we have also three regional treaties on violence against women that sort of complement and build from CEDAW. So one last point, is that I think it's really ironic, that international law, what we do is we require states to adopt sort of more specific laws to address violence against women. For example, laws prohibiting femicide or feminicide, right? Not just homicide, which addresses all human beings, but femicide that addresses specifically women. We ask states to pass laws against rape rather than just having laws on aggression or battery, which technically covers it, but it's not as specific, right? We expect states to have judicial mechanisms, especially trained prosecutors, with a gender perspective to address, violence against women. We do all of these things, and we expect them states to do that. But then at the international level, we refuse to create similar, specific, binding laws and implementation mechanisms within the UN. I think that's really ironic. Yeah.
Well, that's really helpful. And I think our audience is going to be interested to also hear, what does it mean if there's a treaty? How do governments get held accountable to the treaty? Once we have a treaty, what happens? How does a government get held to account for that? When I was learning about this, I was really fascinated that these treaties have created committees where governments really have to come and testify and defend themselves against to the committee to say, this is what we're doing to abide by this committee, by this treaty. And like you say, it's not binding in a sense that there's no UN police force to go and arrest perpetrators, except the International Criminal Court. It's the only one that has arrest where you can actually make an arrest of someone and prosecute someone in a court of law. Treaties are can be considered binding, but also they have to be implemented at the national level, but then through the committees at the UN. So it's complicated, but it's fascinating to see how this is taking shape. So I'd like to turn to Kirthi. Kirthi Jayakumar is a feminist academic working in the spaces of feminist foreign policy and women, peace, and security. And she founded and runs the Gender Security Project. Kirthi, can you tell us what are the legal gaps in Asia that make this treaty necessary in your view?
Hi, Karin. Thank you so much for your question. So I come from the second most populated country in the world, which represents a large population of women in itself. Now, in my country, the legislative instrument governing any form of criminal act and conduct goes back to 1860. It's a penal code, and it was passed and created by the British. Now, this penal code has provisions that are pretty selective in terms of how it addresses violence against women. On the one side, you have a provision which says the crime of outraging the modesty of women is punishable by law. But the same instrument is quiet on something like marital rape or feticide in the most explicit terms. In some ways, this is representative of the fact that the law in itself has not grown or evolved, but it's also speaking to the fact that there is no international instrument to aspire to. India is part of a region, that is Asia, which does not have any regional treaty or convention or instrument addressing violence against women. India, along with China together, constitutes such a large portion of the world's women who are excluded by regional treaty instruments such as the Istanbul Convention, the Belém-do-Pará Convention, and the Maputo Protocol, which simply don't apply because they're not geographically contiguous. And the CEDAW as it exists does not typically talk about ending violence against women. Now, despite having signed and ratified the CEDAW and the fact that the CEDAW has a general recommendation that retrofits the idea of ending violence against women through Recommendation 30, it isn't binding. So a lawyer like me in my country would not be able to hold my government accountable for not adhering to an international basic human rights standard because there isn't one that is defined in hardcore terms to hold my government accountable. Now, the CEDAW has been used to the extent possible to revolutionize the law, as it were, here in India. So in 1997, a woman who was working in a village in the northern part of the country was brutally gang raped. And what happened to her led to a massive uproar in the women's movement in the country and ultimately culminated in the first judicial pronouncement addressing workplace sexual harassment of women. And that eventually led to the first law addressing workplace sexual harassment of women in 2013. But the woman herself, who was brutally gang raped, whose case led to this change, is still waiting for the judiciary to do something to her perpetrators who are walking scot-free. So you see the paradox operating right here. The only convention which talks about discrimination has not been able to do anything for the single woman's story, for her single woman's narrative, which continues in so many ways even today. And on the other hand, has been able to instrumentalize and gather support for a civil legislation and not a criminal prosecution of a very brutal crime. So this lacuna in the law really needs to be addressed. And in my understanding, the best and perhaps the only way to really do this is to establish a one-size-fits-all grand norm of how ending violence against women is in the interest of the entire planet.
So thank you, Kirthi. And in our comments, Rashida commented that the role of the monitoring bodies is important to educate and ensure accountability through the scrutiny of state reports and NGO reports to the UN, and provides an opportunity to submit findings and recommendations to the states. So what you're saying in the case of this woman who was gang raped, with the treaty, how do you suppose that if this treaty were in place and India was a signatory, how would this move the government of India to actually act on her case?
Thank you so much for that question. So, as a lawyer, I can tell you that if India were to sign a treaty calling for the end of violence against women, that would establish an accountability framework for activists and lawyers on ground to hold the government accountable. Now, the Supreme Court of India has been particularly proactive in its journey after independence in really expanding what we know as Article 21, or the right to life under the Constitution of India. So, if India was a signatory to a treaty and one's right to life within the ambit of the expanded meaning from the Supreme Court has been violated, then that gives room for us to use an international convention as a basis to hold the government accountable. Now, aside from that, even to fulfill one's commitments within the ambit of a treaty that it has signed, a government would have to implement or make national laws that are in alignment with the treaty in itself. So, for me, that would look like a revised penal legislation that would typically have ways to codify particular forms of violence against women and outlaw it with penal consequences that are not necessarily going to involve a case being thrown out the window just because there isn't quote unquote evidence. It would also involve a framework of translating action in more intersectional ways. India is tremendously diverse. Accessing the judiciary, accessing legal help, accessing even ways to hold the government accountable still remain the domain of women who are privileged. But if we had a level playing legal instrument to hold our government accountable to, then it really opens up ways for activists to truly engage and make sure that violence against women is addressed in the right way.
Well, thank you. That was a great example. That gives us a really good answer to the question of why the treaty is needed. I appreciate that. So I'm going to turn over to Leila Nazgul Selitbek, who is a Central Asian dissident, lawyer, human rights activist, and campaigner who received asylum in Austria in 2021. Leila is enrolled in University of Vienna Law School and authored and co-authored anti-corruption reports and reports on sexual violence against women. Leila, could you speak more about the experiences in Central Asia and how it's so difficult for women to really receive redress on violence against women? And how do you think this treaty will make a difference?
Yes, so the situation in Central Asia with the instruments and tools available to women and the activists is very much similar to what Kirthi has mentioned. So everybody is functioning at basically absence of effective mechanisms. The region is not covered by any regional treaty. Kyrgyzstan, for example, has an article in its criminal law that prohibits kidnapping of women for marriage, and it has a separate article that talks about kidnapping of an individual. And interestingly, we have noticed that this article that talks about kidnapping of an individual is listed in the section of criminal law talking about crimes against a person. And the article talking about kidnapping of women for marriage is located in crimes against family values for some reason. So the biggest problem we found was not the fact that these actions against women and girls aren't in the books. They are. The problem is their implementation. The problem is also the narratives around crimes that are being committed against women and girls, and just general attitude of the society, the judges, the law enforcement agents towards the victims and towards their families. And I can mention one of the recent examples is when a young woman was kidnapped for marriage. She was raped and murdered, and then her rapist committed suicide. And they were not found by police. They were found in a car. Both bodies were found in a car by a shepherd on the outskirts of the capital of Kyrgyzstan. And during this time, the police was telling the mother of this young woman who was trying to make them look for her that she shouldn't be concerned, that she should go home and prepare for the wedding.
Mm.
There was also an earlier case that was also relatively fresh, and the young woman was also kidnapped, and she was also killed in the process because she was trying to resist. And the parents that were also trying to resist this kidnapping and the marriage, and they were trying to protect their daughter, they were blamed for her death. So that is the narrative.
That's terrible. That's terrible. And do you feel that if this treaty were in place, it would provide for people like you, activists, lawyers, who are really in the communities, give you a way to hold those responsible accountable? Do you feel like if this treaty were in place, it would help you?
Yes, I do. I am absolutely sure it would provide the necessary framework for many things that are missing currently. For example, the activity in training of the judges, in training of police officers, in training of medical specialists that come in contact with the victims. It would also provide tools for the civil society to measure the work that and the efforts that the states are putting into this fight against violence against women and girls. Because currently, and I've been hearing this from numerous scholars in the field, it's actually not even possible to measure the progress. But they don't know what the state is doing. Well, it's narrative, yeah, right? The state can say, well, we have conducted several events, or we have opened a shelter or two, but there isn't a way to actually measure the progress. Mm-hmm. They don't know how much money the state is investing, because there is no how should I call this? There is no way to do it. So nobody's doing it. Nobody has been doing it so far. But I can also, for example, give you an example that Kyrgyzstan has spent $3,500 last year as help to the shelters. That was the help. $3,500.
Not $300,000.
$3,000 divided among 4 crisis shelters.
Right. That's just terrible.
There is something else I wanted to mention, just to give you how ineffective and how unavailable these instruments are in our region. Just recently, there was a decision on a complaint within the CEDAW framework and the decision was made against Kyrgyzstan, and that was in the case of a woman who was subjected to torture and violence in detention, and that was the first case out of Kyrgyzstan.
Wow.
And Kyrgyzstan has ratified CEDAW in 1997.
That's amazing. That's just an illustration of how desperately we need accountability mechanisms, because we know this. I mean, it's basic 101 deterrence. If people are held accountable to the law, it's less likely they will commit crimes. I mean, this is the basic concept of deterrence in criminal conduct, yet somehow violence against women isn't a crime. And so I think you've given a really important example here. And I think I want to ask Francisco to follow up on this question, sort of on the legal gaps, on the normative gaps. And just to say, I think that the exercise of developing a treaty, I've been part of the process of developing norms really for 20, 25, 30 years with the International Criminal Court in the 90s, for example. The process of going through negotiating language or on violence against women. I was part of one negotiation where the phrase honor killing and killings in the name of passion were adopted by the UN. And this had a direct result on the activities of legal aid organizations, human rights lawyers on the ground, to be able to go to court and take a man who murdered his wife because he thought she was having an affair. Previously, the norm there was, well, it was a crime of passion, so he's not going to be prosecuted. This was understood. But because the language was placed in a UN resolution on violence against women in the Human Rights Commission in the year 2000, I think it was, 99, that language was then used by lawyers in Mexico to prosecute men who were committed violence against their wives. So this is real. This is really valuable. And these normative processes of developing a treaty trickle down sort of through the government to civil society, where people really grab onto the language and use it in real cases. So, Francisco, can you talk about what are the gaps regionally, normative in terms of norms, and in implementation? What are some of the gaps that really cry out for this global treaty to be? And as you speak, I'm going to ask Jason to put up the website of the Every Woman Treaty website so we can see where. I'd love to get people to get involved and to learn more about this campaign to create a global treaty. Jason, can you put up the website for Every Woman Treaty? And then go ahead, Francisco, and talk to us about these gaps and why this treaty is so important.
Perfect, thank you. And we do agree that treaties are important. And at Every Woman Treaty, we have identified, as you mentioned, what we call 3 gaps in international law as it relates to violence against women. We call it the normative gap, the geographic gap, and the implementation gap. And we actually provide a lot more detail in a report that we published called The Safer Sooner, which can be found on our website. So the normative gap, has to do with, for example, the failure of CEDAW to include specific issues of violence against women in the text of the treaty. If you actually read the text, it doesn't even mention the words domestic violence or rape, right? And it also fails to address specific groups of women, such as asylum seekers or women in conflict areas or indigenous women, right? Now, we recognize that the CEDAW committee, right, has interpreted the text of CEDAW in several what they call general recommendations, right, to include many of the missing pieces that would ideally fill in that gap. But from a very practical perspective, I think it's incredibly burdensome. It's complicated, it's inefficient, to ask governments to have to go through 39 general recommendations to simply understand what obligations states have to address violence against women under CEDAW. I mean, you would need a master's degree in international human rights law just to be able to understand it, right? And even if you do, those general recommendations that would sort of fill in the gaps of what's missing in CEDAW are not even binding, right? So we think that a much more efficient, more comprehensive, less burdensome strategy for states is to put all of those important normative developments, and those learned from the regional human rights systems in Europe, Africa, and the Americas into a single binding treaty, right? And then the geographic gap focuses on what one of my colleagues and panelists mentioned, the billions of women who are not covered by any specific regional treaty on violence against women. And finally, you mentioned this, the implementation gap that exists because the issue of violence against women is really very much diluted among all the other issues that the CEDAW committee has to address. Again, 39 general recommendations, most of which do not address violence against women. So we want to build from what already exists because we know that existing treaties on violence against women they work, and we can just look at examples from the Americas, where I've worked. We have the Belém do Pará Convention, which was the first international treaty on violence against women. It's much more specific, right? And this has had a very positive effect domestically, right? But also on the cases that have been litigated within the inter-American system. Before we had a specific treaty on violence against women, we had cases in which the Inter-American Commission on Human Rights, for example, would declare, violations of rights to personal integrity, privacy, and family, which are very generic rights that apply to non-violence against women context, right? I always say it's like fitting a square peg in a round hole, right? You're trying to use general human rights law for very specific issues of violence against women, and it just didn't work. After Belém do Pará was adopted, you have cases before the Inter-American system, for example, the groundbreaking case of Maria da Penha versus Brazil, where the holding in the case is very specific, about domestic violence, not general aggression or things like that. And there's concrete results out of that. Brazil passed the Maria da Penha law, which, establishes criminal sanctions for domestic violence. It creates call centers and special courts and police forces for domestic violence cases. And we see that that's the effect of having specific treaties on international law, right? I could mention other cases as well if we have time. But treaties, as you mentioned, matter, and they do have concrete effects on specific people, and we see that at least throughout the Americas.
And one of the comments in the chat, Rashida said, well said, Francisco, a holistic approach on specific human rights violations is imperative. That's a great example of why this treaty is so important. That in the Americas, you had this transnational treaty that forced the government of Brazil to take certain actions that affected one woman's case. But, as we know, these real seminal cases have this larger effect in society. And so just imagining a global treaty really sparking these actions in the courts in every country. So this is sort of the good side of globalization, right? This kind of global norm that really creates this upward pull towards something higher, something better in the remote, in every corner of the world. In the United States, this could be also very valuable where we see gaps. It's incredible, really, that even in some jurisdictions in our country, violence against women is still considered a private matter, where if a man attacks a woman, if she doesn't press charges, there are no charges pressed. Whereas in some jurisdictions, the state views an act of violence against another person as an act against the state. Well, this is the correct way, because it's not just, it's so interesting. It's like, it's not just this woman. Well, this woman is a person. Every human being has the fundamental right to be protected against violence. But because of the social norms that we live with, where private relationships are considered private when it comes to violence, that affects the law enforcement decisions. And so this kind of conversation about violence against women is needed, and this treaty certainly. There's a question that came up in the RSVP that I wanted to put to you all. It's a very interesting question. I know of an effort to talk about what's called non-state torture. So treaties are really holding governments accountable, right? Where governments are held accountable to prosecuting crime. In this case, we're looking at whether the state responds to violence against women through its law enforcement. One question that we have is, can you discuss why non-state torture of women and girls is a universal human rights violation? So there's this concept called due diligence, right? Where the state must act even when it's not the state acting, even when the state is not the violator. So this can deal with this question of non-state torture. Linda McDonald has done a lot of work on this idea of non-state torture, and I think it's a really important question, because often private actors are not seen as violators of human rights per se. If can anyone comment on this this question? Kirthi, I see you nodding your head. Go ahead and take that question.
Thank you, Karin, and thank you for the folks who asked this question. I believe that anybody that perpetrates violence against women, any form of torture, is definitely on the wrong side of a basic human rights standard. Now, within the Every Woman Treaty and the vision for it, and Francisco talked about the Safer Sooner report, we also have a strategy to address what we understand as violence against women across the board. It's a continuum, and this is called the Whole Hand Framework. So what the Whole Hand Framework really calls for is, of course, legal reform at the state level, but it also translates ending violence against women into a very civil society responsibility. So we call for the training and accountability of everybody on the front lines, and then by extension to the entire village it takes to raise every child. Enhance services to support survivors of violence after the incident, to enhance preventive education and make that the ground norm, regardless of what the individual may be in terms of their nexus to society. Enhance funding and data and monitoring as well. So this whole of hand framework is really about reaching out to every actor and agent in society, because violence against women, whether it is state perpetrated, state abetted, state enabled, or unaddressed by a state, is problematic, and it's everyone's problem. So if we want to address it as everyone's problem, we want to be able to ensure that every stakeholder plays a part in ending it. As a peace educator, one of my enduring responsibilities, self-assumed as it might be, has been to sow that seed of doubt in the students I engage with, whether they're in high school or middle school, or even the parents of these students or the teachers, and get them to really think about whether they're okay with a society that has deeply normalized violence. From the personal to the political, violence has been so deeply entrenched that it has now become such an effective weapon of war. The very fact that it remains unaddressed in the peace context makes it such an effective strategy in the context of war. And this is so deeply coded in our everyday thinking. In fact, Jason, if I could trouble you to share a little drawing that I share with my students every time I talk about violence against women. Now, this is a piece of art which I've learned to do recently, but it captures a scene in the sky. This is called the Pleiades, or the Seven Sisters, which is an arrangement of a cluster of stars in the skies. But this tells a story. And the story is deeply tied to mythology across the world, indigenous, native, and Greek mythology specifically. And the Greek mythology story says that the 7 daughters of Atlas were under threat of being raped by Orion. Now, instead of attacking this possibility head on by taking Orion to task, Zeus, the god, converted all of the daughters to stars. And this is exactly what we do as a society. We teach women and girls not to get raped. We're not investing enough effort to tell our men and boys not to rape. We're not shifting the needle in making men and boys stakeholders in a society that can be peaceful and free of violence, because we're so busy privileging them with power, whether through our systems or structures or cultures. So to really sort of tie a bow on that, regardless of who the perpetrator is, a private actor, a state actor, a whole hybrid state, non-state actor, as it were, will have to be held accountable. And that is well within the vision of the Every Woman Treaty.
That was wonderful. Thank you for sharing that, Kirthi. And what you're getting at here is something that's really important, which is the sort of the social norms, the religious norms that are really the undergirding of the problem. This is really and President Carter, when he wrote this book, the reason it's called Women, Religion, Violence, and Power. Women, Religion, Violence, and Power. That's the subtitle of his book, because he says that the reason for this violence against women is the normalization of violence broadly in society. So violence, and he was also addressing the United States, that we have normalized violence to such a degree, warfare, death penalty, pervasive firearms in our possession, violence as a solution. And you add religion to this, it's quite explosive. Pardon the pun. It is quite difficult problem, because you have created this religious kind of normative social norm that is very hard to break indeed. And we have in our work over the last 15 years or so encountered various groups that work with this idea that social and religious norms have to be confronted. And so part of the book that President Carter wrote was really about, and Jason, if you could pull up the video, I have a personal message from Jimmy Carter that we recorded some years ago that I'd like to share with the audience, because it really is going to take all of us, the vast majority of people in the world are religious, and we have to find ways for people of faith to really act in alignment with human rights. This is happening in kind of various places, and we've kind of been involved here and there. It's very challenging, but nonetheless, it's very important. So I'd like to just play a message of invitation from former President Jimmy Carter, if you could go ahead.
The Carter Center is advancing the rights of women and girls and moving beyond violence in our families, communities, and nations. I'm asking you to join me in this work. There are many ways to get involved. In my book, A Call to Action, Women, Religion, Violence, and Power, I provide 23 recommendations for action. Our Forum on Women website will host roundtable discussions and post articles and updates informing you about how you can help. Please consider what personal actions you can take in your family, school, or workplace, in your church, mosque, or synagogue to stand for equality and peace in our world.
So a few years ago, President Carter became very sort of captivated by this problem. And as a practicing Christian himself, confronted his own church. In the 1960s, his family left the church, or in the, I can't remember what year exactly, over racial segregation. And then later, he and Mrs. Carter very publicly left the Southern Baptist Convention over the issue of discrimination against women, because women were excluded from leadership in the church. And so he decided it was really important to speak out as a human rights advocate, but also as a Christian, to challenge other Christians to align their religious belief with human rights. And so we have encountered a number of organizations and individuals who have really taken this on to really work within their faith communities to talk about how every person is a child of God, and that religion should not be used to oppress women or to foment racial violence. So I want to ask each of you about this. How do you think this can play a role? I think Kirthi's example is a great one. It comes from mythology, which creates this kind of narrative about women that is really hard to break. Leila, I'd like to ask you, what role do you think religion plays, negatively or potentially positively as well? Can we reach out to people of faith in a way that will bring them into the human rights campaign?
I think that that is a very good idea to seek their involvement and to ask them to support this message and to participate in development of the narrative, of the correct narrative in the society. Unfortunately, without going forward with this initiative, we are going to face situations like we had with a religious leader in Kyrgyzstan who just recently made a statement to his followers. And he has many of them because he's one of the popular ones. And he basically said, if they see a woman whose clothing seems to be too revealing, they have a full right to rape her. So yes, I think that would be a very important step to ask the religious leaders to support us in this fight.
One of the things that I've seen happen, for example, in this, as an example, in response to this terrible edict, this terrible announcement. I mean, it's there is a sheikh in West Africa who we encountered, who was trying to work. Basically, what he did was he traveled to Al Azhar to get a ruling on genital mutilation, to see whether this was allowed in Islam. And the religious scholar said, no, this is not, it is not allowed in Islam. It is a cultural practice. It's not a religious practice. So he went back to Senegal and started to teach the other imams that this was not a religious practice and that they should stop. This has had this chain reaction effect where villages are abandoning the practice of genital mutilation, many thousands of villages, and they do it as a collective announcement. So that the problem is that if a girl is not cut, she can't marry from a neighboring village, and she's not marriageable, as they say. So they would do this in large networks of villages, make a collective announcement that this practice is ending. But by the imam being part of that, and by the elderly women who were doing the cutting themselves, they did a joint announcement. It had this effect where the practice was ended. So this is an example of what can happen when when this is challenged. It's very, very difficult, very problematic for a lot of reasons. But when it works, you can see some of the most. I'll give another example. An imam that we worked with in Nigeria was so touched by this program where the same sheikh had delivered a class in how the Quran supports human rights, that he went home and he had 300 imams that reported to him in Nigeria, and he led a class on ending genital cutting. He brought in a physician to talk about the harm to girls, the physical harm, in going in great detail about the medical side of it, the physical side of the practice of genital cutting, but also on the religious side, the idea of equality and well-being and love for the fellow human being. And these 300 imams then were leading efforts in their own communities. So I think that it seems this can be quite a difficult and hopeless case, because when you have a story like this of a religious leader that uses their power to actually foment violence against women, you think it's just an impossible task. But I do think that we see it happening. We see people challenging those religious norms, and this is definitely going to have to be a part of the campaign to end violence against women. Now, the treaty itself, of course, applies to governments, and coming back to this due diligence principle, that governments then must work to make sure that if such a person, religious leader, calls for violence against women, then there must be action against such a person. This can't be allowed. A religious leader cannot be allowed to incite violence this way. Francisco, let me invite you to comment on this idea about social norms, religious norms. How can those be impacted? Is there any connection between this and the idea of the global treaty?
Yeah, definitely. I mean, taking the last point that you mentioned, I think you mentioned that states have a responsibility to, to act with due diligence, for private actions, so states may be responsible under international human rights law for private actions, where there's no state involvement. If the state fails to act to do, for example, for investigating, an alleged violation of violence against women, for failing to punish acts of violence, and for failing to prevent violence of these rights. But, why a new treaty, would be a step in the right direction, to address state responsibility for private actions is, if you look at CEDAW, the text of the treaty itself, only applies to violence perpetrated by public authorities, right? it is the recommendations of the CEDAW committee that extend this responsibility to private life explicitly, right, as well. But if you look at the more specific treaties on violence against women, if you look at Belém do Pará, the Istanbul Convention, and the Maputo Protocol, right, those explicitly mention, right, state responsibility for acts of violence against women in the private sphere, meaning by non-state actors. And that's in the text of the treaty itself, not in a non-binding general recommendation. And I guess another comment that I want to mention about the role of religion, while it can be certainly positive, and we hope to have the support of religious leaders, in the struggle to get a new treaty on violence against women, there are certain religious positions that may actually be quite difficult to address, in the treaty of violence against women. We see this under CEDAW on the issues of abortion, so I'm sure that's going to come up. But also on issues of sexual orientation and gender identity. Would acts of violence against women and against a transgender woman, would that be supported by the religious communities, or even by governments? So that's a big question that we have to make sure that we address head on. But generally speaking, yes, states do have a responsibility to make sure that not only state actors don't commit acts of violence against women, but that state actors prevent acts of violence against women by private individuals, and that they act with due diligence to actually investigate and punish those acts if that's the case.
Thank you very much for that. That was really helpful. Well, we have a few more minutes, and I really want to give each of you an opportunity to tell our audience how they can become involved through their own community organizations, individually, through their own government. I know that there have been a number of governments that have signed up to the treaty. The Carter Center has a number of programs in the Democratic Republic of the Congo, so I was happy to hear that the Congolese government has signed up for this, which is quite interesting given the level of violence against women that has taken place in Eastern Congo in the war. I lived in Zaire when it was Zaire, which is now Democratic Republic of Congo, when I was quite young, and before the war, there were violence against women was, in terms of this kind of violence that we've seen in recent years, since the war, was just not present there. I traveled freely through the country, and I knew a lot of women, and issues of rape were handled at the village level, where perpetrators were held accountable. And so what we see as the violence against women in the war in the East is really a new thing for the Democratic Republic of the Congo. So I was happy to see that government signed up for the treaty. But I know some others have. What can people do? I'd like to pose the question to each of you. What can our audience do to contribute to this effort? Let me start with you, Kirthi.
Thank you for the question, Karin. I would say start where you are. Wherever you live, you know what the problem looks like locally to you. So open up and have conversations and talk about amplifying the call for something like a treaty and why that would be a good idea. But aside from that, I am a beneficiary of an incredible program run by the Every Woman Treaty team called the 1000 Voices Fellowship, which really takes you through understanding the dynamics involved in calling for a new treaty and explaining why the existing legal systems are inadequate. So if you find yourself as someone that could be a very useful voice in this cause, I would definitely encourage you to reach out to the team at Every Woman Treaty to sign up for the 1000 Voices Fellowship.
What a great suggestion. That's very practical and helpful. Leila, please give our audience some advice. How can they become involved?
Yeah, there's really not a lot I can add to what Kirthi said, but yes, get involved, take action where you are, look around, see if you can help the local NGOs or join a local activist movement that's participating in this work. And yes, I do think if that is something that you're interested in doing, to reach out and join the 1000 Voices program and reach out to the Every Woman Treaty team. that would be, I think, a wonderful experience.
And I think that the Every Woman Treaty organization can help plug people into what is happening with their own government. For example, if somebody is watching this from, Ghana or another country, the Every Woman Treaty could probably direct them toward where the government of Ghana has stand, what outreach has been made. Maybe this person watching this program would want to encourage their own government to join or to sign up for the treaty, to support the treaty. So that's another way. Francisco, what advice do you have for our audience members who'd like to participate?
Yeah, just to build up on what everybody has mentioned, Every Woman Treaty really has activists, as part of our network in 128 nations across the world. So chances are that we can mutually benefit from getting in touch with each other. We can help put you in touch with other activists in your country so that together you can advocate within your own government, to support the call for a new treaty. And we could use your help to be able to have those conversations with diplomats, that we're always having with different ambassadors of different regional and international systems at the UN, the Inter-American System, European Council, African Union. We could use specific voices, right, from all of these nations around the world, so we can actually, tell those who are in a position to actually move the treaty forward, why the treaty is needed, right? And why it's going to benefit you individually and the people in your country as well. So I think we can benefit mutually. So we just get in touch with Every Woman Treaty through the website that I believe has been put on the chat.
Yeah, Jason, can you go up and put up the treaty website again, just to really reinforce that? And then, it's really exciting to be part of a process of developing a new norm. It was some of the best experiences I've ever had have been in Rome, helping to shape the language of the International Criminal Court, or in Beijing in 1995, which was very exciting because we were all sitting on the floor, handing notes to the delegates, giving them language for the Beijing platform, which is still the best global document on women's rights that there is, the Beijing platform. And that was shaped by NGOs, individuals that really pushed governments on specific language. So it's very exciting to be part of a process that is going to result in a treaty. So I really encourage anyone watching to visit the website, find out who's involved in your country or in your region, and just get involved. It's going to be a thrilling process. And at the end, people said the International Criminal Court would never happen. In the 90s when we were working on it, they said, no, it's a pipe dream, But look, it's working. Even it has its difficulties, but it's doing what it was meant to do at the international level. But it's also pushing governments at the national level to prosecute war crimes and crimes against humanity, even at the national level. So they won't get called to the International Criminal Court. So it really does have this dual process of creating a global norm, really calling nations to a higher standard, but also giving fuel and encouragement to the local activists to really, really help their society meet that new standard. So thank you all for joining this conversation. It's really fascinating, really educational, informative, inspiring. And we really look forward to staying in touch and being involved and keeping everybody informed about what's happening with this Every Woman Treaty project. So thank each of you. Thank you very much.